Good afternoon, and welcome to the final panel of this conference. Start with a point of uniform agreement. The EU, the United States, those are both models of political, economic, legal integration, but they're very, very different models. There'll be some disagreement as to what those differences are, how they have played out, and what the responses to sort of recent challenges are. We have managed to agree on an order of speakers. So Craig will start. That'll be the 10-minute version of the Parsons Project, after all, at the end of the conference. Melissa Holyoke will go next. We will then hear from Susanne Schmidt, and Jerry will hit cleanup here. The rules are the usual, okay? 10 to 12 minutes. Let's go. Craig.
All right, here we go. I heard 12 minutes, didn't you?
Oh, yeah.
Thanks. Well, so these sessions have exceeded my expectations, been fascinating. So what I'd like to do is make some very big picture, somewhat historically removed points about the comparative governance of internal market openness inside the EU and the US, which I've been studying with a team of people, including a few others who are here. I'm hopeful that the other presentations and then maybe discussion will sort of connect some of my big grand points to some more contemporary stuff. But so my point of departure is that there's a common wisdom out there about openness in the European market relative to openness in the American market. And so EU leaders and many, many observers bemoan the incompleteness of the EU single market fairly constantly. And in so doing, they often refer to an image of the United States as a wide open market as sort of the image of what they're trying to achieve. Now, that common wisdom isn't wrong if by market integration, we're focusing on economic integration on the ground. Of course, the United States has higher trade and mobility. Across the EU has achieved a lot, actually, in those categories, but nonetheless, the US is well ahead. You know, these kinds of things like you see here. But that common wisdom also includes things like this, and you hear it all over the place. So this is an article from The Economist in 2019 that was about the EU single market. And just in passing, they're basically saying the EU single market is having trouble, and they characterize the United States as a single economic zone with nothing to impede the free movement of goods, services, people, and capital. And now, that part of the common wisdom, which is a claim about what governance looks like in these two places, is just simply wrong to an extraordinary degree. So if you ask which of these places has a stronger and more complete, in a sense of sort of systematic, governing regime for market access across internal borders, which one has done more to get rid of internal regulatory barriers, the answer is clearly the EU, not the United States. Now, here are the basics of that comparison, with apologies for extremely brief assertion of extremely complicated things. So just to touch on each of these cells. So you look at the legal jurisprudential standards of what the state-level governments have to do with respect to openness. So the Supreme Court has invoked this dormant commerce clause, has found the standard that states can't purposefully discriminate. Okay, that's the basic idea. Whereas the comparable standard in the EU is this much, much stronger standard. In fact, I think it's basically the strongest standard one could possibly imagine, which is that the treaties are found to imply that members can't hinder or render less attractive market access. Okay, so jurisprudential standard much stronger in the EU. And then the difference gets bigger as you go into more active governance in terms of legislation that's actually trying to turn those jurisprudential standards into active law. If you go looking for federal legislation in the United States, of which the point is to facilitate openness across the states, there is surprisingly little in this category, and I can show you data about that if you'd like. Whereas there's a whole lot that we know about if you have ever looked at the European Union at all. There's this whole single market project. Is it incomplete? Of course it is, but they've been trying really hard for 50, 60 years to legislate fairly systematically and turn those principles into law, more active law. And then administratively and in terms of enforcement, well, since the US federal government doesn't have many laws that are trying to achieve or impose internal openness on the states, well, big surprise, they don't administer or enforce that principle much. Whereas the EU, the poor little EU, which is not a giant bureaucracy, chases its member states around to the best of its limited resources a whole lot to try and enforce those principles. So now, some immediate qualifications, right? There are sectoral exceptions to the pattern I'm just showing you. So in finance, telecoms, transport, the US federal government, there is pretty strong federal legislation. We have pretty nationalized markets. Those same sectors are, to some degree, exceptions in the other direction in the EU. They're the nationally reserved powers. And those are really important exceptions. Nor am I telling you that the Europeans are anywhere close to a complete thing where they've gotten rid of the regulatory barriers at their borders. But what I am telling you is that, contrary to this common wisdom, Americans encounter quite a few regulatory barriers at state borders, including quite a few that the Europeans have gotten rid of. And so Melissa is going to talk about this Supreme Court ruling in pork producers last year, which is about the wide latitude that we give to our states to exclude goods from other states, which you couldn't do in Europe. In services, we have tons of varying state requirements. Fragmented professional licensing is a really common one that people talk about. Europeans have done a whole lot to facilitate that. For example, you might remember, if you follow European things, 20 years ago, the Polish plumber was the big thing in the huge political mobilization around the EU Services Directive. Western member states didn't want to see cheap Polish plumbers take work from the good French and German plumbers. But the Polish plumber ended up with strong market access rights, where their qualifications roughly need to be respected in these accepted in other member states, whereas Oregon plumbers, you need twice as many hours of experience if you're an experienced plumber from another state to be able to apply for a license in Oregon, and that's actually one of the more open states in that respect. Okay, now, we've heard other examples in some of our discussions here, right? Bo Rutledge showed you yesterday about the hodgepodge of jurisdictional claims with private law. That was one that I didn't know about until yesterday. We have in the US, explicit interstate discrimination in public procurement and in subsidies. I could actually go on for quite some time, but the big thing I want to claim is that the headline here on this slide is unambiguously true. In terms of governance, the EU has a more complete internal market. And we Americans quietly live with quite a few visible, unmistakable regulatory barriers at state borders. Okay, now, that's not supposed to all come up together. Oh well, there it is. I don't want to get too social sciencey on you, but I am a social scientist. And if you were a social scientist, and we were trying to predict in which arena we would expect to have seen the development of a strong internal market regime, I submit that what we see is exactly the opposite of what you would have predicted. So in the United States, we have, again, higher interstate flows, and for all sorts of reasons you can see, shared language and identity and a relative culture of mobility, although mobility has declined by half across the states since 1950, which is interesting. Big federal government that does all sorts of things that homogenize the economy to a certain degree. Much larger big business share of the economy, right? And so in a simple political economy sense, what that means, all those things mean that there are more people and firms who cross those borders, who incur costs if it's a regulatory pain in the butt to do so, right? And fewer people, relative to Europe, who have vested economic interests, or let alone cultural attachments, which is really obvious, to these state lines, right? Plus, we supposedly have a famously pro-market culture, which seems like fertile ground for an internal market project. And institutionally, our federal government was mainly set up, arguably, or at least, the historically leading reason for setting up the Federation, right, was this Commerce Clause, which at least could have been turned to these purposes, you might have thought. Meanwhile, the EU has all the opposite of all those things. So I don't even need to summarize the right side of this, because my point is it's actually it's surprising that there's a non-barking dog on the US side. Why not more of an internal market project? And a surprisingly barking dog on the European side. Okay, so what I'm in, again, to be a little social sciencey, right, to explain what has happened, to explain these outcomes I've just laid out for you, there's something really non-obvious about how the EU managed to pull off the creation of such a strong regime, despite not especially favorable conditions for them. And on the American side, right, we should see it as non-obvious why American interest groups and policymakers don't care more about using that available federal authority to reduce interstate regulatory barriers. We've heard a lot of the previous panel made a bunch of remarks about the US Chamber of Commerce and business seems like it might want a more systematic set of rules. Now, okay, 2 minutes, here we go. This seems especially puzzling in the last 50 years or so, which is, since the 70s and 80s, is ostensibly a big shift towards pro-market politics, right, in both arenas, at least a while back now. And that's when the Europeans go on this internal market crusade, and you do get powerful pro-market politics in the United States, but without any attention to these issues. Now, don't just take it from me that this is a puzzle. Let's take it from Antonin Scalia, right, who said at, I think it was the inaugural meeting of the Federalist Society in 1982, he mused about why it seemed that pro-market conservatives essentially had seemed to be forgetting the Hamiltonian reasons why the US federal government was created. And so he says here, why does it not even occur to those who believe strongly in a policy of market freedom to have it adopted by federal legislation? Essentially, why isn't anybody acting a little bit like the European Commission in the American context? Now, Scalia's answer to his own question was basically that conservatives had overreacted on some level to the New Deal. They'd adopted such a strong anti-federal line that they threw the Hamiltonian federal baby out with the progressive bathwater. I think there are other things to add to that explanation. I'm actually, in the interest of time, there's a little bit more about what the Reagan coalition was like, other states' rights components to it, and I think there's some institutional features of how our Congress is set up that make it difficult to pull this off. But anyway, together with Scalia, I would basically agree that the US stands out. We have a rather weak internal market regime due to a distinctive ideological context in which the business and pro-market parts of our polity developed a special antipathy in the last 50, 60 years to federal authority, even for pro-market purposes, which is interesting. Now, there is a parallel story to be told on the European side, which I've written a book about and in a bunch of articles, and I could tell you that, but again, in interest of time, just the basic idea, there's a very distinctive European fusion between a federal central authority building project and their own version of pro-market thinking, right, which essentially takes the same issues in a different direction. Now, let me, however, to conclude, that's data I could show you. Okay, I've got this last slide, it's a little complicated, but then I'm gonna stop. So I'm going to cleverly avoid a direct answer to the question I posed by saying that neither of these policies has got it right in any simple sense. My point is that they're both path-dependent, rather strange, ideologically skewed arenas in this respect. The comparison, though, does hold some lessons for each of them, and this is, sorry to be ridiculously brief on complicated things, but so the EU, it's a truly remarkable project, and truly we just should be astounded that they pulled off what they have pulled off in Europe. That project has some real costs, right? To pursue such strong openness across such a diverse arena has encouraged a huge production of central rules, an overproduction of central rules. And in such a diverse arena, overproduction of central rules has a real democratic cost. In terms of economic benefits, it does have economic benefits in many ways, and a lot of econometric studies will show you that. But it doesn't quite have the benefits that the EU sells for it because, as you see in the comparison to the US, it's not ultimately a regime for cross-border market access that makes the most difference in whether you have a free-flowing economy. We have a pretty free-flowing economy for all these social reasons, essentially of social and lower-level institutional homogeneity. The US firms are scalable despite a fragmented set of regulatory regimes because the next jurisdiction is legible and reasonably familiar, and you can just pay the regulatory costs and still scale. And that's the fundamental European problem. And so ironically, I'm not saying the single market project isn't worth pursuing further, and there's more work to be done, capital markets notably. But ironically, the spread of English might do more for the scalability of European firms than anything the EU can do. Okay. I'm sorry, I'm here and I'm an organizer abusing the rules, but to be quickly, on the US side, right, it really is weird, I think, and I'm a Europeanist coming back for the first time ever to study my own country in this project, so my own views are a little skewed. Nonetheless, we're really weirdly not interested in these issues, which are visible, and you go talk to businesses and they will tell you that these things are costly. It hasn't been a huge problem for our economy because we have all those other essentially sort of functional equivalents, favorable conditions, despite a fragmented regulatory regime. But now, red blue state divergence, we're going to hear a little bit about that, is going to sharpen those costs from regulatory fragmentation. If you're more on the left and you care about the green goals and the implementation of the climate transition, we heard some about this earlier, those jurisdictional issues and essentially the weakness of American federalism in some of these regards are a real problem. So I'm not so naive as to think my last line is here, oh, so let's just change American federalism. That's a big ask, but we might want to start thinking about it.
Thank you, Craig. Melissa.
All right, thank you so much, Michael. Thank you, Donald. Thank you, everyone here. This has been fascinating. I'm very excited to be here. And particularly among my fellow panelists, I will start with the standard disclaimer that the views I express today are my own, and they do not necessarily represent those of the Federal Trade Commission or any other commissioner. So prior to joining the Federal Trade Commission, I was the Solicitor General for the state of Utah. And as the chief appellate advocate of the state, Utah would often file amicus briefs by itself or together with other states in various appellate courts or with the U.S. Supreme Court to let the court understand the interests of the state and its citizens. And so I just want to begin by reading an opening paragraph of one amicus brief that Utah joined, and this one was actually led by the state of Iowa. So to keep in mind, Iowa is about 1,000 miles away from the Atlantic Ocean. So here's the opening paragraph. Suppose Iowa voters began to worry about overfishing and the inhumane harvesting of Atlantic shellfish. So the Iowa legislature passes a law about how lobsters, clams, and steamers must be harvested to be lawfully sold in the state. For examples, lobsters must be able to turn around in their lobster cages that capture them. Perhaps the Atlantic fishermen think that the rules are unworkable and would dramatically raise the costs of otherwise ethical fishing. Iowa neither employs nor consults experts within the field, and the Atlantic fishing community is simply not that large. And so, without fishermen to raise their concerns with local legislatures or voters, this new hypothetical law is enacted. While this hypothetical posed by Iowa seems extremely far-fetched, it was not so different than the reality Iowa was facing in other states regarding restrictions on pig farmers. So this particular case, where we filed this amicus brief, involved a Massachusetts regulation that banned the sale of pork products that do not meet Massachusetts standards on the size of pig pens. But remarkably, as Iowa points out, Massachusetts residents annually consume 396 million pounds of pork, but produce only 1.9 million in the state. So it thus produces less than 1% of the pork it eats. The Massachusetts case, that's still pending, but pork producers were not so lucky in their challenge to a similar California law that reached the U.S. Supreme Court. There, the National Pork Producers Council argued that the California law violated the U.S. Constitution under what is known as the Dormant Commerce Clause, and that's what Craig was talking about a little bit earlier. So the Constitution, it empowers Congress to regulate commerce among the states. And so the negative implication of that is that the Dormant Commerce Clause is the idea that it's unconstitutional for individual states to unduly burden out-of-state economic interests. So in this U.S. Supreme Court case, in a very fractured decision, I mean, it's almost like a Venn diagram of who agrees with who, with different arguments, there were different groups of justices adopting various conclusions. And the majority of the justices recognized that the very core of that Dormant Commerce Clause, as Craig recognized, was discrimination, preventing discrimination among the states. In other words, the court's previous cases prohibit the enforcement of state laws driven by economic protectionism, that is, regulatory measures designed to benefit in-state economic interests by burdening out-of-state competitors. A state law thus offends the Dormant Commerce Clause if it is facially discriminatory, or, under a balancing test, if it imposes a substantial burden on interstate commerce such that its practical effects disclose a discriminatory purpose. So in National Pork Producers, you would think that would be the case, and many of the justices agreed, except that, like Massachusetts, California imports 99% of the pork it consumes. But since California was not trying to protect their own pig farmers, it was free to regulate those farmers outside of its borders. The California law went into effect January 1st, 2024, and thus far has resulted, unexpectedly, in even higher prices for consumers. Economists with the U.S. Department of Agriculture observed that price increases of 16% for bacon, my particular favorite, and 41% for pork loin for California consumers. Unfortunately, this burden largely impacts California's Hispanic and low-income communities. And not surprisingly, California's fresh pork consumption has dropped from 10% to 8%. The long-term impacts on the market, on the pork market are really pretty unclear, but the university studies predict that to become compliant, it will cost more than 40% more than traditional barns and 25% more in conventional group housing. But more importantly, from my perspective, what's concerning is it's likely that many of these small farms will be forced to decide between exiting the business or entering into a production contract, resulting in fewer, larger farms owning a greater portion of sows in the U.S. Of course, as a commissioner with the Federal Trade Commission, I'm tasked with promoting competition, protecting consumers. So this is troubling for me to hear of a market faced with decreased competition and higher consumer prices. Even if the FTC is unable to address these, what's really interesting about this pork producers case is, I think, the important constitutional tension that we see and that Craig has touched on a little bit, and where this could lead. And so a little bit of background, and this is mentioned a little bit. In the 1780s, shortly before the Constitution was adopted, state interference with interstate commerce was cutting off the lifeblood of the nation. So it became one of the principal reasons for adopting the Constitution, or why states were able to convince each other of ratifying it. It was to create a national economic market to overcome state restrictions on free trade. So like the trade barriers before the Constitution was adopted, the California law denies market access to out-of-state pork producers unless their farming and production practices in those other states comply with California's dictates. Of course, the states are empowered to regulate within the borders. So when the states, this is the tension, when the states ratify the federal Constitution, the people of each state acquiesce in the transfer of very limited power to the federal government. So the Constitution is silent about the exercise of a particular power, that is, where the Constitution does not speak either expressly or by necessary implication of some certain power to the federal government. The state is either delegated by the state or retained by the people. So this constitutional structure provides for lawmaking by governments more local and more accountable than a distant federal authority, and allows states, and this is a very popular term in the United States, to serve as laboratories for novel social and economic experiments. So as a former state solicitor general, and I was very involved heavily in defending the states and in state laws, I emphatically support states as laboratories of democracy and protecting the state's sovereign authority to legislate. So I share the concerns recognized in the pork case of like very expansive dormant commerce clause, which could authorize judges to just strike down duly enacted state laws based on their assessment of the relevant costs and benefits. But I'm equally concerned, as I pointed out, to some of these competition and consumer protection issues. I'm also very equally concerned about states' legal experimentation where out-of-state industries are the actual guinea pigs, as in California and the Massachusetts case. So practically speaking, what happens is this legal experimentation favors states with large economies. So in national pork producers, because California constitutes 13% of the consumer pork product, it's economically infeasible that many pork farmers will just exit the market. With a population of 38.9 million, California constitutes an important part of nearly every market. So by contrast, my lobster example, my Iowa lobster example, with Iowa's population of 3.2 million, it would not likely be very costly for Atlantic fishermen just to simply leave the Iowa market if faced with an Iowa regulation on lobster cages. Interestingly, the states of California and New York, with larger economies, also tend to have left-leaning state economies, liberal legislators and voters that support economic regulation more than their conservative counterparts. So after, what's gonna happen? So after national pork producers, it's very likely that we will see these far-reaching regulations to continue for a couple of reasons. First, the dormant Commerce Clause no longer stands as an impediment to extraterritorial regulation. And so while a regulation could still be overturned if the burden outweighs the benefit, some of the justices in that opinion really basically provided a pathway to overcoming that balancing test. And so what these justices noted was that the task of balancing the burden on interstate commerce with the benefit that is not economic is practically impossible. So this, as Justice Barrett explained, California's interest in eliminating allegedly inhumane products from its markets cannot be weighed on a scale opposite dollars and cents, at least not without second-guessing the moral judgments of California voters or making the kind of policy decisions reserved for politicians. It's impossible for a court to basically balance the burden and the benefit when the competing goods are incommensurable. So, in other words, if a law purports to serve the moral and health interests of the people, how can it possibly be weighed against an economic burden of compliance? But what this means is states faced with creating extraterritorial legislation will likely seek to justify their interstate burden by simply pointing to these benefits, moral and health benefits. And this is likely not going to be very difficult because many of these extraterritorial regulation involve issues such as the environment or labor. So it will be easy to justify those laws. And then second, where state regulation burdens out-of-state businesses more than in-state businesses like in national pork producers, this far-reaching regulation is also likely to continue because it lacks this immediate political accountability. So in California, for example, the state legislatures are not faced by all the pig farmers knocking on their doors trying to get this law overturned. And from a democratic perspective, it's troubling that a state could be legislating for those who do not appear to be particularly accountable. I believe the market solution is the best here, where consumers already can choose pork products with labels that state pigs here were, raised crate-free, and it better serves principles of democracy because consumers can vote with their pocketbooks every time they go to the store. And just to conclude, this, if you think I just care about pigs, I don't. I love pigs, love bacon, but this is actually permeates the market. We'll see it in energy, environment, just about everywhere. And I think that the Scalia quote was excellent, as it points out there are some areas where just a congressional federal legislation that would, for a national issue and for the FTC purposes, like data privacy security, might be the best approach to permit so that companies won't have to face this consolidation, these competition problems, this regulation problems of this patchwork of different regulatory bodies. But and just so you don't think that I'm like completely Debbie Downer, the one on being able to challenge extraterritorial regulation, Justice Kavanaugh, in his concurring opinion, talked about how there might be a pathway to challenge this under Imports-Exports Clause, the Privileges and Immunities Clause, Full Faith and Credit Clause. So we may see those challenges come up, and someone might pull that out of their playbook, and we'll see. We'll see what happens. But thank you.
Thank you.
Sorry, I'm just flipping through my extra slides.
Okay.
There you go.
Right.
Now you're good. If anyone wants to ask me about the polls that you just saw there, you can do that.
Okay, great. So thanks a lot. Thanks to Mike. Thanks to Craig for having me. It's been a really interesting 2 days, and now I have the chance to also go back to some of the what was said by my colleagues in the first two panels. So it's really astonishing from a European point of view that actually the US, as a kind of archetypical capitalist system, does honor cultural, historical, whatever diversity so much more than the EU. So my question is, how does the EU manage to agree on common policies across all these differences? And we've already heard a lot. So I will be quicker on some things and more focus on others which we haven't heard. I think really fundamental is the interaction of two fundamental institutional characteristics of the EU, and we've heard a lot how case law of the ECJ, how the treaties, how the four freedoms really push along integration via country of origin regulation. And then we've also heard about cooperative federalism being the implementation side and the kind of rules which bind and which make problems Gareth alluded to. So I will focus on these two things, being quicker on the first. And I think the interesting bit for us is really that this great achievement of the EU, the single market, is always the one which is taken if there's a crisis, or let's focus on the single market. It's the great achievement. I see people nodding. And I would say it's also the seed of its demise, because there is the problem of integrating via rules. And that's what we have here in the panel description. It's about integration via rules. So let's see, common policies. And I will say a bit more here and then skip some slides. There are problems of mutual recognition. I mean, we have this strong case law, the four freedoms, so there is a need to accept the origin principle. And Jan Zielinski, in his talk, he alluded to all this legislation already. There is a lot of legislation. Why is it? Because firms don't really want to operate via case law. It's difficult. It's difficult for administrators to have all this case law. And so there is a strong rationale to go along and codify this case law. And then, of course, it's many different interests in legislation making the babies fat. So we have quite complex rules. But this is particularly for product standards. It's not so much for process standards. And then I'll come to the cooperative. So I look at regulatory competition linking into what we heard now about the pigs case in the US in a second. But then we have the, to draw your attention to this interaction, we have the cooperative federalism. And of course, if I have implementation in my hands, I can kind of look for wiggle room. I can customize. So it makes it a lot more acceptable to have these big European rules, because at least I can kind of see how it's being implemented. Okay, so let's skip this. And we've heard there is a lot of legislation, but this works really for, I mean, Jan had product standards, services is already more difficult. And for process standards, when it's about production processes, it's a lot more difficult. So there, member states obviously want to keep their competitive benefits. Posted workers is like something always big in this context where we actually have harmonization, but often we don't have harmonization. And if we look at animal welfare rights, California can enforce its host principle. This kind of gives the chance. We had it with clean air and automobiles, the California effects. It has a high standards. Everyone upgrades in standards. But in the EU, you have the regulatory competition. So actually, Germany, for more than 20 years, has been really contentious. The very low standards for pigs and other animals. But it's not possible to upgrade that, because pigs producers will always come and say, oh, but then pigs will be, we won't have pigs production and they'll just be imported. So my point here is that we have extraterritorial effects in both cases. It's either the kind of political from outside. So we can't really escape that. And if trade based on origin rules undermines national policy preferences, it also is difficult. But let's focus a bit more on cooperative federalism, because I think we've had it here and there in our talks, but we haven't really looked at it in greater detail. So positively is that administrations may use their powers, their interpretation to create wiggle room, and we have all these European rules and they get acceptable because on the lower level it's being adapted to the conditions. But negatively, the EU is a government of governments. So the EU lives on the legitimacy of national government. And I mean, I think Alistair somewhere cited the polls, and the EU is high up. Great, but I mean, why is the member states so down? It also has a lot to do with all these rules and what Gervers was referring to, that it's really difficult to do things. I mean, I'm from the town of Bremen, which has now to struggle with post-COVID as many other cities and wants to do some town development. So they've been struggling how to construct a legal construct to pour 300 million into some society to evade European procurement laws, because then they first have to do a EU-wide bidding and they lose a year and the electorate thinks nothing is happening. Of course, there are so many lawyers here. I'm a political scientist. Everyone will know this is probably not litigation proof, but that will fall on the feet of another government. And I think that's a real problem for national legitimacy. And of course, we have scapegoating in either direction, and who knows where do these rules originate? I mean, I've been studying the single market now for decades. I couldn't tell you in many aspects, and it's tremendously complicated, and that's a problem. So we've already listened to implementation. I skip over this. Dan told us the Commission doesn't really pursue infringements, and of course, uneven implementation is also a problem. And what I see is we have a lot more regulation now via regulations and not directives. So we have all these EU rules. So in a way, I have the feeling it's a Europe on call. So if you are a big company and you think, okay, I can profit from this, then you kind of activate it. And is that a good system? So I still have some time now to give you 2 slides of a summary and kind of thinking further. The single market relies a lot on court decisions driving it. Before we had all this case law in the 1970s, in the 60s, the 6 member states couldn't progress. So that's a lot behind it. But cooperative federalism does give you some leeway, so that's good. The problem is these rules which are being implemented, if they are weakly legitimated, it works as long as they are positive sum rules, if they give benefits to everyone. And we've heard time and again in our 1.5 days that trade is beneficial. Trade is beneficial, but nevertheless, of course, there are distributional effects. Some people gain more than others. They have to be paid off. And we have this accountability and legitimacy problem. So to conclude, what are the lessons? There are significant political costs of these economic benefits. Rules are overly complex. They are highly bureaucratic. We've heard from Gareth, there's also a low accountability if it's court-driven, even though we have then the Parliament and the Council coming back afterwards. I've studied many policy processes, and it's always, oh, well, we have the case law anyway, so we have to do it. It's either we kind of make it more transparent or we just leave it. But there will be the case law. So there are many constraints on member states for problem solving. And I alluded to the Bremen example. And I think what the problem is, when integration really relies on having common rules, it's really difficult to ask, do we need these common rules? And actually in our joint project, I've been studying the construction market. there's really small rationale for having common standards for construction products if member states are responsible for building safety, and these are heavy products, and you have local architects and the rest. But there is tremendous harmonization activity in this area, all, of course, costing administrative capacity for little economic effects. And I think that's a problem. And we've been talking about the crisis. Of course, populism is closely connected to non-accountability, to constraints on governments, on problem solving, and it's also closely connected to judicialization. And that's where I stop, and thanks for your attention.
On the second, Susanna, that was impressive.
Okay.
Be hard to follow that up. Yeah, I'll try to come in less time. So I want to start by thanking Craig for inviting me, and thank you to Mike and especially to the Law and Economics Center staff for hosting me so graciously. And I also want to thank all the participants for an incredibly informative and spirited set of panels over the past 2 days. I've learned a lot. Going last, in a way, is a great joy and a great burden. It's a joy because there's so many stimulating ideas to respond to. And it's a big burden because I was up at 5:30 this morning trying to think about how I wanted to revise my comments today in response to some of what I've heard over the past 2 days. So my task, as I understood it, was to say something useful about federalism, and in particular about American federalism, since I'm an Americanist. So I'd like to make 3 points which I hope will be sufficiently provocative to generate discussion. I'm not going to try to sum anything up, but I want to make some provocative comments, some of which are complementary and others which go against some of Craig's points. So my first point is that it may make more sense to conceptualize federalism according to the qualitative relationships between the federal government and states than it does to do it by an ordinal account of relative sovereignty. That is, according to a continuum from centralization to decentralization. Second, although fragmentation in the United States can lead to incoherence, inefficiency, and immobilization due to the multiplication of veto points and the cost of regulatory duplication, it can also lead to more uniformity across subunits because organized interests have been learning how to venue shop in order to create state-by-state rules that add up to more than the sum of their parts. The third point is normative and way more speculative. Namely, if we think of federalism qualitatively and relationally, rather than according to some ordinal continuum of sovereignty, then the normative issues may be less about centralization or decentralization authority, or even about the uniformity or diversity of rules, but rather what role can different levels of government play to support one another in achieving effective problem solving, amelioration of paralyzing conflict, and democratic accountability. So let me try to very quickly unpack each point as much as I can in the little time I have. Excuse me for a sec. So first, how should we conceptualize federalism? Well, I think that Professor Galston was correct in the opening panel when he said the U.S. built a more centralized federal system in the decades after the New Deal and the Second World War. It's pretty important to also recognize that centralization came in a lot of different forms. Even the most centralized regime, a regulatory regime like telecommunications, where there was a single regulator, federal regulator, overseeing a single licensed monopoly, AT&T, was marked by a complex system of separation agreements between the FCC and the states over regulatory responsibilities for long lines and local telephone exchanges. We might think of this qualitatively as a system of shared sovereignty. By contrast, we might think of civil rights regulation after the 1960s qualitatively as a centralized system, but as a hierarchical system of centralization in which the federal government supervised elections and education in the states. Or we might think of environmental regulation as a more independent system of centralization because federal regulation inevitably involved state agencies. My second point is that it's a mistake to think that fragmented federal systems always result in incoherent patchwork of rules. This is because organized interests have become much more sophisticated in recent years in venue shopping, not just to find the political sites that favor their interests, but also to strategically build broader regulatory or deregulatory regimes. We've learned a lot in the last couple of years about how the American Legislative Exchange Council has been successful in enacting uniform deregulatory, fiscal, and restrictive labor law policies across the states by building associations between conservative legislators across state legislatures. And today, as progressives are revitalizing aggressive antitrust enforcement at a federal level, some members of the labor movement, union members, are really beginning to think in very sophisticated ways about how to leverage a renewed interest in the law of vertical restraints to help them organize against a company like Amazon, which exercises a great deal of control over subcontracting truckers through its delivery service partner program. Unions have begun to try to target specifically states' attorney generals in these early efforts to reconstruct the rules that simultaneously govern employment subcontracting and that govern also employment classification. Or think more simply about how the current antitrust case against Google involves both the Department of Justice and an organized coalition of bipartisan attorney generals led by the Attorney General of Colorado. In short, the organized interests and states' attorney general are really learning in many ways how to coordinate activity to build more coherent rule regimes than we can capture by automatically correlating a strong federal system with rule diversity. My third point then is normative and a whole lot more speculative. Although the first 2 points are pretty speculative. They're meant to be provocative. My third point then is, as I say, normative. If it's helpful to conceptualize federalism relationally rather than by the distribution of authority, and if organized interests have become more skilled at using fragmentation to try to build regulatory and deregulatory regimes, common rules across states, maybe we should ask what roles different levels of government can play in supporting one another in problem solving and overcoming the political impasses which result from competing organized interests, instead of asking whether authority should be centralized or decentralized, or whether rules should be uniform or diverse. I'm good. I think I can finish in less than 5. And I know I can, actually. I think the advocates of experimentalist governance, who aren't represented here, except for me, I suppose, in the EU and the US pose precisely these sorts of normative questions. Here I'm thinking about the work of Charles Sable and Jonathan Zeitlin and their many collaborators. Sable and Zeitlin argue that instead of thinking about centralization, decentralization, or rule uniformity versus rule diversity, we ought to focus on how centralized institutions of authority can facilitate learning, performance upgrading, and accountability among diverse subunits. In the US, for example, their colleague Bradley Karkanen showed more than a decade ago how progress was made in clean water and endangered species regulations when federal regulators set broad goals and ceded implementation to the states, with the proviso that the states agree beforehand to a set of performance metrics and report back regularly on their progress to federal regulators. For their part, federal regulators abandoned dictating solutions to the states and instead coordinated benchmarking between states and consultancy about how laggards could improve. My point in pointing to their work on this work on experimentalist governance is not to say that this is a particular architecture for federalism that should be the wave of the future. Instead, it's to say that thinking about rule uniformity versus rule diversity, or questions of where particular sovereignty lies, instead of thinking about those questions normatively, we ought to focus on what sorts of relations between states and federal governments make progress on pressing problems, ameliorate intractable political conflicts, and advance democratic accountability in very different kinds of policy areas. In my way, this way of thinking about federalism, not that particular architecture, but this way of thinking about federalism relationally and qualitatively is not only more useful normatively, it also resonates for me quite a bit with what I've heard over the past 2 days.
Thank you very much,
Finish before.
Jerry. Totally impressive. The entire panel, completely impressive. I'll abuse the time now granted to me for the following purpose. I want to give the speakers a chance to respond to each other, but I'll ask, if you don't mind, some leading questions, which you can feel free to sort of completely ignore or focus or complement with comments on the other speakers. Craig, starting with you. What you describe, the sort of contrast between the EU and the US model, I think fits recent decades very, very well in most respects, but it wasn't always so, right? So as Susanna described, in the initial phases, the EU project was a court-led project, right? That's true of the origin rules of Cassis de Dijon. That's true of legal supremacy, which sort of the ECJ in those days fabricated without any legal basis in the treaties that was discernible. And it did that because it wanted to sort of ramp up. I mean, it had to promote the integration project before there were institutions, political institutions that were capable of doing that. Interestingly enough, the Supreme Court, over its first 150 years, had very much the same agenda, right? Integration in the United States was court-led. Congress had absolutely nothing to do with it, right? And the chief instruments that the court deployed was the doctrine of Swift versus Tyson, federal general common law to integrate the economy, and the dormant commerce clause. There were 400 plus cases between 1870 and 1928, right? And the force of those doctrines you can see in sort of industrial development, right? Why is it that corporations, big corporations, developed in America? And the answer is those doctrines, federal common law, the dormant commerce clause, allowed those corporations to operate on a scale that was unavailable in Europe, right? All of that disappeared in 1938, right? Federal common law disappeared because the Supreme Court said it doesn't exist, okay? And the dormant commerce clause was greatly weakened. And what Bo Rutledge described yesterday, what Melissa described today, that's the culmination of that trend, right? The court has, despite a constitution that envisions courts as the first protector of economic and political and legal integration, the court has abdicated, willingly, deliberately abdicated at that front. Now, and so what distinguishes in that perspective the EU from the from the US project is that once the ECJ had got going, the EU actually responded by building up institutions that were capable of delivering on positive integration, as the EU calls it, and the Congress has never done that. My question to you, Craig, is I take your point about very little legislation, federal legislation, that is overtly pro-integration, right? But the form which it takes in the United States is preemption doctrine, right? So the statutes look like, that's federal overreach. Once, yet again, Congress is meddling in the poor states' affairs. The reality is something different, right? Business has to, on important issues, operate across lines. They say, look, we can't have 50 different standards. That's ludicrous. Therefore, Congress, please legislate, right? And the quid pro quo that we need is you preempt state law. And if we're really serious, we'll have something like complete preemption, as under the National Bank Act, ERISA, right? It hasn't always worked that way. As one of the panelists described, Jerry, you mentioned that, I think the FCC, most of these regulatory regimes leave some room for, state activity. None of these compromises are very stable. But I'd just be interested in sort of, Craig, your reaction to, how do you classify, how do you think about those kinds of political compromises that are both integration and regulatory harmonization, whatever you want to call it, right? Melissa, I remember sort of, this was before you were born, but it was in my living memory. During the first Reagan administration, many of our common friends, Doug Ginsburg, Krista Muth, the late Bill Baxter, realized that the real monopoly threat in the United States are state-imposed monopolies, because they're exempt from antitrust scrutiny in the United States, and they tried to do something about it. The Congress stopped them cold. Now that we no longer have a Congress that can stop anybody cold, is there, and I ask you in your private capacity, not in your capacity as a commissioner of the Federal Trade Commission, is there any room for administrative agencies to sort of think in a more competitive federalism mode, or is it all, we just think about efficiency and that's all that interests us, right? So are there regulatory regimes that sort of are more open to sort of, we have to take the federalism dimension of what we're doing here into account? I have one question, Susanne. You had a terrific point, I thought, which is about origin rules and the implied contrast to our dormant commerce clause. So our dormant commerce clause means simply you cannot treat outsiders worse than your own, right? That's a non-discrimination rule. The origin rule, the Cassis de Dijon rule, is also a non-discrimination rule. But, it's a non-discrimination rule that makes your teeth bleed because, you have to admit products that you would not allow your own citizens to produce and sell in that state. That no longer looks like non-discrimination, that looks like forced entry to me, right? And you have a non-discrimination rule like that if you're in a hurry, like the ECJ was in the early years. But could it be the case that there's so much pressure for, as Jan said, for harmonizing rules, even preemptive rules on occasion in the European Union, precisely because the costs of the origin rule are so severe, and is there room maybe for the European Union to think more carefully about non-discrimination rules along our lines, right? Just don't treat outsiders worse than your own. And is there a way to operationalize it? And finally to Jerry, I take your point. Let me play devil's advocate and say something along the following lines, and this is sort of standard in the legal literature. The great advantage of federalism, you might argue, is not that states and the federal government, federal agencies can cooperate in some functional fashion. It's that state governments are the last line of resistance against an overbearing, omnipotent executive. And sometimes they resist by just suing the living daylights out of the feds, right? And sometimes they resist by what Heather Gerken calls the servant's power, that is shirking, right? You tell us, I mean, you need our cooperation. Well, good luck to you. Either you give us more money or we shirk and don't do what you want, right? There are reasons to be concerned about that. But there are also reasons to sort of celebrate the sort of potential for friction and resistance where it might not otherwise materialize. So those are my questions. Feel free to ignore them. We'll go in the same order in which we started. Craig.
Great. All right. Well, thanks, Mike. Fantastic questions. Okay, so starting with preemption, so U.S. steps in any of the directions I've been talking about it's effectively about preemption, and it's important to see that all EU legislation is preemptive, right? The EU does nothing itself, as the cooperative federalism model that Susanna is talking about. You're always the EU can only, since it's such a tiny little thing, can only act through by telling the states what to do, right? So it's preemptive, it's telling them what they can't do, and sometimes forcing them to do things. And so now the United States, of course, in our historical origins around what was, at one time this dual federalism model with a really strong separation between the two levels, has, of course, just a basic systematic bias against preemption, right? And the notion there's a background notion that it would be desirable that these two levels operate sort of separately, and that we should put a really high, a lot of scrutiny on the notion of federal preemption, right? So now, that said, and especially as we get into the era of modern regulation, and certainly past the New Deal, there are the legislation you mentioned, right? There are times in which, despite that sort of bias or set up in the system, federal legislation does punch through it, occasionally for reasons of openness, the Interstate Banking Act, or things like that. Although usually, since the vast majority of all that federal legislation, modern regulation, right, is since the New Deal and is for these essentially more left-leaning prudential reasons, driven by people for whom openness in the markets is not at the top list of their concerns, right? So, of course, we do have lots of federal preemptions. We end up with only erratic ones that fall in this category of federal preemption for the purpose of interstate openness, right? Now, okay, so both these systems are heavily court-led on the front end, although I think in somewhat different ways. So the EU, and this is what a lot of my early scholarship was about the early years of the EU. So the EU in the 50s and 60s, absolutely, it's super crucial that the court goes way out on a limb, beyond what anybody expected, and has its sort of Marbury moment and declares its own power, and then finds a bunch of other powers in the treaties. But crucial to see that, and what a lot of people don't know, is that, the early treaties were created by a clear elite minority of supporters of a supranational Europe who really wanted that kind of thing to happen. But they didn't have the political support to do so. It's extraordinary that they pulled it off to the extent they did. They're definitely a minority in all countries, and what happens is they nonetheless, amazingly, through a story I could tell you if you gave me a couple days, they set up these institutions. Then the court, to their own surprise, starts building a legal structure on that basis. But it only really takes off once there's this political fusion in the 1980s between that still minoritarian and quite elite project of essentially European federalism and this broader phenomenon, or at least different phenomenon, of neoliberalism. It was a very awkward marriage initially. Margaret Thatcher didn't end up loving it. But those two things then come together to empower the broader story that I've told you. So yeah, the courts are there, but there's actually people behind, first prior to the court in the U.S., in the EU case. In the U.S., it really is court-led for a long time, I think. I'm not an Americanist. I'm just beginning to learn things about this weird country. But of course, all that happens prior to the rise of most of what we think of as modern regulation, if you will, right? And so you set up a system there is a phase of really active, it seems EU-like, but it's in a time period in which you're not dealing with these complicated issues of division of labor on complicated regulatory things, right? It's at least somewhat, it's similar, but not nearly as complicated as it gets later on, and it doesn't involve as active government role in the economy. But part of the story that one could say that some of the story I tell about the U.S. doesn't have an internal market project, you could say, this whole thing got set up in the 19th century around some court decisions prior to the rise of modern regulation, and we sort of never moved on to a phase like the EU, which would require sort of more actively pushing internal market politics through a landscape of modern regulation. That's true, but what I want you to see in talking about Scalia's talk in 1982 is that, so yes, the United States comes in the 20th century with that setup. There's still a question to be asked. We could, in the 1980s, have imagine a pro-market American politics that did pick up those issues, right? If it weren't for some other features of the Reagan coalition, that is to say, I think had things gone a little differently, we could have imagined that a pro-market push in the 1980s and into the 1990s would have had at least some sort of internal market liberalization as a piece to it. As evidence of this, look at Canada and Australia. Okay, so the EU goes off in this direction in a big way in the 1980s and 1990s. Canada and Australia, with politics at least a little bit more similar to the United States, both in their ways in the 90s and early 2000s have an internal market push, essentially, partly directly inspired discursively by the EU, but they liberalized their own very balkanized, fragmented internal markets. And it's the US actually is the outlier of advanced market federations that doesn't pay any attention to these issues, right? So yes, it's founded on court decisions in the 19th century. I think we can imagine an alternative world in which we would have taken a different path, interestingly, later on. Sorry, that was really long.
No, it was excellent. And I do want to say just a few things. I do want to respond on that complete preemption, because I agree with you on many of these things. I think what's happens with the states, particularly conservative states, because of the extent of federal overreach, when there is any sort of legislation, federal legislation, they get really anxious and nervous about this idea of any complete preemption. They want to maintain their ability to legislate in a field. But the problem with that is it basically sets a floor across the country where then without a ceiling, and other states will come in and legislate quite heavily, and it's almost as if there wasn't any sort of nationalization of some sort of policy. And so you have then we have issues like I was talking about before, where you have these larger states that are actually in effect legislating nationally because they're setting higher standards than what the national standard is. And you have markets that need to respond to those because those markets are so large. On the second one, and just to respond to what Gerald was talking about, and I love the idea of cooperation. I think that's fantastic. When I was in the state, and I led most of the oversaw our multi-state work, including a case against Google, a different one, Utah versus Google, with 50 states, so it was bipartisan in nature. But I would say that those types of lawsuits are much smaller in terms of multi-state work. It's probably like 5% bipartisan, and the majority of our cases are going to be are not bipartisan. We see a lot of bipartisan work in the antitrust and consumer protection fields, but in the other fields, what you would normally see is a group of red states going against the federal government, and then a group of blue states coming and intervening, trying to be on the other side. And you will see the same thing happens in a change of administration. Like even before Trump, you'd have a big group of blue states against the federal government, and the red states would come in. So you'd see more of that than what would be, I think, a productive cooperation there. And then also with ALEC, I think that was an interesting point too on the conservative groups coming together, because what's interesting is you'll see pockets of coalitions, and all of a sudden I find myself just on the phone with Louisiana for not like they're my neighbor or anything, but we're very much aligned in a particular issue, and now we're working together on a specific piece of legislation that we both really strongly agree with. So I think, which ends up helping probably markets in terms of trying to have fewer types of regulations to comply with. But I do think you still end up with lots of different groups there, and still, even it might not be a patchwork of 50, but it ends up being still a patchwork of quite a bit more, still quite a bit to deal with. On the state monopolies and what can federal administration do about it. What's interesting is, my concern is these regulatory burdens that are going to lead to consolidation, and we will continue to look at mergers and to see if they benefit consumers. Then we won't interfere. If we think that they will harm consumers, we will interfere, and that might be the problem. Is they might be consolidating because they are faced with terrible regulatory burdens, but we could still inevitably challenge them, and then really who harms in the end is probably going to be consumers and markets and innovation and quality, and all of that comes from a really strong national markets.
Yeah, thanks. Let me be quick. I see Dan there. Yeah, I fully. It's if we have a normal non-discrimination rule as it used to be in the beginning of the EU, it would be more like the pigs in California, and you just cannot discriminate on the basis of nationality. If it's non-restriction, as it turned then in the 1970s, it's a question of whether you hinder. And now, of course, there's disagreement. I mean, Jan would say, oh, there's a lot of deference and there's much one can do, but that then only works with product standards and not with process standards, which may not be harmonized at all, and it's just a matter of the whole market. And with product standards, I mean, for product trade, you have very strict deadlines. If a member state wants to object to a product being imported, they only have a few weeks to say so. So that's a lot of pressure, and then they rather have harmonization than this pressure of monitoring, particularly, I would argue, in this construction business where it's important that you don't have dangerous products doing something. So let me thanks, leave it at that.
Thanks for that devil's advocacy.
It comes easily.
I take the point really seriously. I mean, the way I read Karkanen's account of the Endangered Species Act is that it was precisely the states defending themselves and developers in alliance with the states protecting themselves against a pretty restrictive, very restrictive, pretty overbearing set of rules in the Endangered Species Act that led to endless litigation and to response. But Karkanen's argument is that in that particular case, what happened was things became so stalemated that even the states didn't get what they want, and even the developers did, because people just kept playing a procedural game, right? That locked up the ability to make advances on habitat and on development, and so. Nobody designed, according to Karkanen, no one designed that experimentalist system, right? It kind of emerged out of the political stalemate, out of some attempt to break that political stalemate that came from the legitimate response of the state to overbearing regulation.
Dan.
Thank you.
You're on.
All right. So, this question kind of touches on things a few of you have asked, or a few of you brought up. So let's see who gets talking. I just want to start by reading Article 12 of the 2008 EU Directive on Pig Welfare. Okay? Member states may, in compliance with the general rules of the treaty, maintain or apply within their territories stricter provisions for the protection of pigs than those laid down in this directive. They shall inform the Commission of any such measures. Now, this goes to the point Melissa was just making about floors being put in, not ceilings. And I mean, in I haven't followed these things for a while, but I used to work on this. And, I thought the typical pattern in the EU is much more establish minimal standards, but if states want to go higher on some public policy ground or animal welfare ground, they can. Same with mutual recognition. I always thought the impact of mutual recognition as a principle was really exaggerated in the sense that, people act like, oh, that is going to, be like a sort of steamroller over national discretion and divergence, but actually mutual recognition had right in it exceptions for grounds of public policy, animal welfare, national security, et cetera. And so then, just to touch on what Susanna said, maybe the question is first to you, Susanna, but really anyone else. I mean, the way I was hearing what you were saying, you were depicting that, in a lot of things, choice is taken away from states where they can't go higher, right? You were kind of implying more that there's ceilings also, right, on regulatory choice. But isn't floors rather than ceilings the more typical EU approach? Or am I just out of date? Thanks.
Can I sort of ask with a point of fact, and maybe and either Susanna or somebody else in the room may know this more solidly than I do, but what I think I know is that the regulation or directive, whatever it is you read, council directive, thank you. A member state is allowed to set higher requirements for raising pigs on their territory.
Sweden has higher.
Right, so does Austria. But Austria can't exclude the Polish pigs, right, that are raised in the way the Poles determine, right? A plumber, yes, right. And that's different.
Let me just jump in. I mean, the question is one of then regulatory competition and whether you win the regulatory game at home. And you may, but like in Germany, they didn't. You have an electorate, you have polls, and you see they actually want higher standards. You have a high farmers lobby, and they say this won't do anything because if we have to raise them to higher standards, we are just being inundated by Polish pigs or Dutch pigs, I don't know. And so it's no use, and they win the game.
Okay, so you
And-
do it, but you're pressured.
I didn't say you couldn't do it. I'm saying that mutual recognition does work for these processes in the form of regulatory competition and competitive pressure. And there, I think, then it all depends. And if Sweden, fine, they have higher pig prices. So.
Yeah, and so the Iowans would have nothing to complain about.
Here's what we're going to do. No, Angelica, I'm not going to stop. Sorry. I'll cannibalize the time we will cannibalize the time for adjournment, which will take only 2 minutes. We'll take 4 more questions, and I'd be grateful if we could sort of keep the questions and the responses brief. Go, Gareth.
Okay, there's a challenge. Thank you very much for that really interesting panel. I'm fascinated by the question of why Europe has so much more regulation than the US, and you gave a lot of answers, but just 2 thoughts which you hinted at and maybe your reaction. And one is, it was mentioned, I once sat through a course of EU law in France which didn't mention the Court of Justice. Disputes that are interesting. We're looking at the text. That's the law. I don't know if even Catholic universities in the US teach the Constitution without referring to the Supreme Court, but I suspect not. And attitudes towards precedent, court case you can't do it with judgments, basically. Lots of member states just ignore them. There's a huge literature on mutual recognition and Cassis de Dijon, how academics find it massively exciting, but the member states just ignore it. So, I mean, I don't know if to what extent this plays a role. And the other thing is, of course, the tradition in Europe is to regulate everything. And that's not to do with the EU. Prior to the internal market, all the states regulated everything. I interrailed in Germany in the 1980s. It was like the rich Soviet Union. All shops had 5 kinds of products. They were all the same. They were all excellent. It's just like, and they regulate every service. And so that creates much more need because you've got and I would imagine that in the US, if you have 2 states that regulate pigs, you're like, okay, they regulate pigs, whatever, live with it, that's life. If 41 states have regulations on pigs, you've got a disaster. And then maybe the federal legislature starts thinking, we need some federal law on pig cages and so on. I don't know if that's what happens in the States. We're very interested to know. But the default position of Europe to regulate every product and services creates a much greater need, perhaps.
Can I just add one word to that so we can answer it together? Mike, is that all right?
I have never known you to utter a single word.
I just want to say,
Go, Alistair.
as a background to what Gareth has just said, right? Article 100, remember, in the old days, every single directive had to be unanimity. And it was only when we launched the single market in 85 that we brought in the Single European Act, which introduced Article 100A, which allowed qualified majority voting for internal market directives, because we had 9 member states, and we had 10 member states, and then we had 12 member states. And Cassis de Dijon, yeah, I guess Gareth is right, member states ignored it and all that, but it was our fundamental principle, because Lord Cockfield and Mr. Delors in 1985 said, right, we're going to not have total harmonization as in the old days, we're going to have, and I'm going to quote the phrase, minimum harmonization of, listen, of essential requirements of health and safety, complemented by mutual recognition of equivalent national standards, right? And so Cockfield said, we're going to cut regulation, we're just going to harmonize at EU level the minimum, and then we'll rely on mutual recognition. That has died the death. Why? Because in a union of 28 states, 29 members, 27 member states, maybe 40 in the future, mutual recognition doesn't work. The Finns don't know the Greeks. The Slovenes don't know the French. And so we got into total harmonization. Which are the 2 areas where we launched total harmonization? European rulebooks, as Neve said this morning, financial services, and food law. So that didn't dictate that every member state produces the same food, but it produced a common standard across a 27-member state union. I don't know what that means for the United States, but that's a kind of brief history of how we got to total harmonization, because mutual recognition doesn't work.
Alex.
Alistair, we have 50 states, not just 27. Thank you to this panel for a really interesting and profoundly important discussion. On behalf of the financial services panel, I wonder if banking doesn't actually give us a great example. Michael mentioned the National Banking Act. Think of the National Banking Act in its original form going back to 1863 was a national chartering, but it by no means created banks that could operate nationally. They were banks that were bound to operate in single states and to respect the rules of each state. And that wasn't broken for 130 years. Now, the other thing that came out of the panel, which I thought was so interesting, was your point on the EU coming out of a minority elite group, but then the politics shifting. Similarly, in this national banking case, as we began the formation first of interstate and then truly national organizations, the politics shifted. As I mentioned Charlie Calamiris earlier, said the politics of United States banking shifted from a fundamental alliance between small banks and rural populists to an alliance between big banks and urban populists. And that completely changed the politics and allowed this formation to go. And so as we think about levels of sovereignty, it seems to me a truly fertile idea to try to track with that these kinds of underlying cultural or political or belief system alliances as they move. And I really, that was a terrific point that came out of the panel.
There's, just very briefly, there's actually sort of, it's going to be a question for Jerry. This may be the kind of thing you have in mind. The way we overcame, sort of part of the way in which we overcame sort of state chartered banks operating exclusively within their own domain was state-initiated mutual recognition, right? Because Massachusetts banks wanted to compete with the big New York banks, and they couldn't ramp them up to scale without sort of having regional compacts. And so what they said, Massachusetts said, was, okay, fine, you, Connecticut, if you let our banks operate in Connecticut, Rhode Island was part of that. I can't remember what other states. You can open up branch banking in our state. Very dubious as a constitutional matter because you discriminate between and among states. What the Supreme Court eventually said, this was in the mid-1970s, I think, was that, Congress and the Federal Banking Authority have already authorized this under some federal statute, and so they were permitted to sort of operate under a de facto congressionally approved regime, and that's how we eventually ended up with sort of de facto national banks.
That's really
Right? It's an actual sort of intragovernmental innovative story, not totally clean, but actually one of the better examples of how market integration can actually work. I apologize for that outburst. Tom, John.
It's a great example.
My question is for Jerry because I think he may have underestimated the fiendishness of Michael's original question to you. And that is your third point about essentially cooperative federalism in the United States, and the speculative benefits of it. Can you give any examples of how regulatory processes or even the content of regulation has been improved by the sort of Hodel model where Congress says, look, here are all the rules. You have to adhere to each one of them. But if you would prefer to regulate strip mining in your state rather than have us do it, we'll let you be our agent. But we'll watch over you constantly and take back your authority if you fail to toe the line. How does that hold hope for the improvement of regulation in a federal system?
I mean, I think the case of endangered species is the case that to me is the clearest one, because it is a case that it's not a case where Congress authorized state discretion or a lower level, even below state level discretion. To habitat conservation planning, right? It's a case in which the Clinton administration, facing regulatory wars and litigation and endless political stalemate, and the inability, I think, to make progress on both economic and environmental issues, threw up their hands and said, okay, we'll try these experiments. So I don't think that there was people didn't think through an architecture of how to do this. I think that it was, in a certain sense, out of exasperation, and what people hear most about, is the armed sit-in at Malheur in my state of Oregon, right? But what they don't hear about is what happened in my state as a result of habitat conservation planning with the sage-grouse. They don't hear that there are a lot of ranchers in the state who actually learned things about grassland conservation from having to face the issue of dealing with sage-grouse habitat that they otherwise wouldn't have learned, and they themselves claim it. They themselves came up with the phrase, what's good for the bird is good for the herd. So it's a cute one, but I think it's an important one to see, especially because the picture we have of rangeland regulation in Oregon and Nevada, was armed conflict, right? That resulted in a death.
I should say Utah farmers feel very differently about the sage-grouse.
Jonathan, very briefly, truly last question. and then I'll bring down the hammer.
Question. The comment is we have to be careful about using the Endangered Species Act as our model because A, some of the Clinton administration stuff was illegal, and B, it's expressly not a cooperative federalism statute. So it's not a model that applies to any of the pollution control statutes. The question I have is in thinking about the extent to which federal action facilitates either harmonization or standardization or an open market or allows for or encourages balkanization, to what extent do we have to go beyond looking at or beyond a formalistic reading of what the statutes say and think about the political economy of policymaking once federal law is in place? So, for example, there's an argument I've made that the pattern we see in environmental law of states being more active, more aggressive, and more innovative in those areas where the federal government regulates less means that a lot of floors are in fact de facto ceilings, especially over time, and that if the federal government, as it has, devotes a disproportionate amount of time to what are essentially localized or regionalized environmental problems and ignores interstate ones, let alone global ones, it's actually encouraging states to devote their resources where state resources will do the least good. And so apart from the balkanization open market dynamic, we have a fundamental poor misallocation of resources, of scarce resources to deal with things like environmental problems, where neither the federal government nor the states should be the exclusive actor. Rather, we want each to be acting where it has a comparative advantage.
All right, I'm going to go quickly here. I mean, I'm finding myself surprisingly, I agree very strongly with your point that, I mean, ultimately, sectoral problems are different, right? And I mean, we're in our single market study, we're looking deliberately at difficult single market sectors, so construction, spirits, and we're just getting into retail banking. And as Susanna was emphasizing, I mean, the sort of single market push in construction in the EU is sort of nuts, right? and you should have definitely different degrees of caring about having uniform rules in a construction sector as opposed to some others, right? So I think that's right. The problem is that politically, it's hard for polities to not apply cookie cutter, so that, right, polities come up with institutional schemes and start applying them, right? So, I mean, which of course is just an argument for all the more vigilance about the point you're making. Okay, super quickly, just Alex on, no, okay, I'm gonna, the point about banking was fantastic, but I'm just gonna say to Gareth, less reliance on precedent in the EU context, which you know more about than I do, but that's of course presumably related to why, so then active legislation is all the more important, right? So the Commission needs to feels a real need to take this up and push it into legislation, right? Because that's sort of part of the system. More regulation in the EU. Actually, I'm willing to accept that sort of in the backdrop to my whole contrast is a much more regulatory activist context across the board in Europe. And so if you're going to aspire to any sort of internal market openness in Europe, you're going to be having to push sort of stronger single market rules across that space. But think about this. What that means is in the US side, because it's broadly a lower regulation context, it should be easy. There should be lower hanging fruit, right? It's easier to do this if all your regulations are a little lower, and especially given the homogeneity of it. I mean, so on the one hand, maybe the gains are less from just lower, or harmonizing already lowered regulation. But gosh, the differences between the states, I mean, some of the things like Bo was putting up, or if you think about professional licensing, the issue is not that the license here has any different requirements from the license there. It's purely that your license is no good over here, and when you go over here, you have to do all the training again, right? So, as opposed to in Europe, where the Finnish qualifications are really different from the Portuguese qualifications, right? So there's a real issue there. So it's still, the question persists on the U.S. Like, really, there's some gains to be had from, and not actually so many losses from some sort of coordinative role across not very different spaces.
Ladies and gentlemen, we have finally reached the end of this this conference. I thank you all for participating so cheerfully and eagerly and so informatively. I want to thank the LEC again, Donald, for sort of sponsoring and hosting this. I want to say a special thanks to Angelica, Gwen, Heather, Colin, for sort of just terrific organizational assistance with all of this throughout the preparation phase and the conference itself. Thank you all again. Please join me in thanking the panelists of this final panel for a stimulating, informative debate. We stand adjourned, and we'll have drinks at the Pirouette. Thank you all.